Custody and child support don't have to be scary. In this video, I'm going to show you a few things that actually decide both and how to keep it calm and predictable for your family. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group here in Miami, the firm that makes lives better in and out of family court. Over my 20-plus year career, I've been involved in thousands of family law cases. Sometimes that's meant bold representation, but often it means simple steps that lower conflict and give you control. Because when you're facing a divorce, one of the biggest concerns people have is the kids. And the uncertainty of what custody and child support will look like can keep people in toxic relationships for years. You want your kids to be stable. You want your money to be predictable. You want less drama, more clarity, and a plan that you can live with. So take a breath. You're not stuck. You just need a clear roadmap. And I've got you. Here's what we'll cover together in this video. I'll explain how custody works in Florida in plain English. I'll show you how judges and parents can set the overnight schedule. I'll walk you through how child support is calculated and why overnights matter. I'll give you 3 quick scenarios that you can relate to. Then I'll clear up a few myths and give you your next best step so you can move forward with confidence. But just know, this is only about custody in Florida, and it is just information, not legal advice about your specific circumstances. For advice about your situation, talk to a Florida family law attorney like a member of my team. Custody doesn't exist here. Here's a translation that changes everything. In Florida law, we don't actually use the word custody. We split that idea into 2 separate things: parental responsibility and timeshare. Parental responsibility is decision-making ability. It answers who says yes on the big stuff like school, healthcare, and activities. Florida's default is shared parental responsibility, which means both parents make those decisions together unless a judge decides sharing responsibility would be detrimental or bad for your child. Time sharing is the overnight schedule. It answers where your child sleeps on school nights, on weekends, and holidays, summers. It's different from decision-making. You can share decision-making and still have more nights in one home than the other. You can also have decision-making over certain things like school or medical care, even if the other parent has more nights in the time-sharing schedule. Bottom line, you can think of it like this. Parental responsibility is who says yes on the big stuff, and time-sharing is where your child sleeps on any given night. They're related, but different concepts. So how does the time-sharing schedule get decided in Florida if you, as the parents, don't agree? The courts will start with a presumption that equal 50-50 time-sharing is best for the child. It isn't like the old days where kids almost always went with the mom and dad got every other weekend. This is how I started my practice more than 20 years ago. That means the judge starts at 50-50, but can change it if they believe that a different schedule is in the child's best interest. But to move away from equal time, you have to present a really solid case. Best interest sounds fuzzy, but it is real life. Who gets the child to school on time right now? How well do you communicate? How far apart will you live? Your work schedules, your child's needs, especially if your child has special needs, stability, safety. It all gets factored into what will actually work for this child, in this family, in this season of life. The presumption is just a starting point. It is not automatic. A judge will look at all of the factors if you two can't settle an agreement. Now, here's one misconception on time-sharing that I'll explain more later. If the schedule ends up 50-50, that does not mean there's no child support. Time-sharing is a big factor, but the child support number still depends on a whole lot of math. Here's a few examples of why a 50-50 equal time-sharing schedule would not work. First, distance. Long distances between homes can push school nights to one home with longer weekends or more time in the summer for the other. It keeps sleep and school steady. Next, if shift work or unpredictable hours in one parent's work schedule can make a regular routine fail, so the parent with more stable hours is more likely to get more overnights. Here's a big one. High conflict. If the court believes that handoffs between you and the other parent can harm the child, the schedule may change so there's fewer handoffs, neutral exchange locations, and longer blocks to reduce friction and keep the focus on the child. If your child has special needs or regular medical care, they may also need steadier routines. So if one parent is more likely to provide that, they're likely to get more overnights and more time sharing. And of course, any serious safety concerns can drastically change the plan, even removing time sharing from one parent altogether. These will typically be things like documented violence in front of the children or untreated substance abuse. But it can also be living conditions, like if one parent lives in a shared space with other unrelated adults. But remember, time sharing and decision making are separate. Even if the court decides you get more time sharing, that doesn't mean the other parent loses shared responsibility and decision making. So let me give you some examples on how this might actually play out. Family A lives 12 minutes apart, and both parents have steady daytime jobs. They communicate well by text. The child is in elementary school with no special therapies. Everybody knows a routine. In this case, a true 50-50 works. There's a couple of ways to do 50-50 that I'm going to explain in another video, but the vast majority of the nights will be split evenly, with holidays and school breaks usually alternating. Now compare that to family B. Mom and dad live 45 minutes apart. Dad works nights and weekends. The child has speech therapy near the school every week. Exchanges are difficult and tense. This is not likely to end in a 50-50 split. This would be more likely to end with maybe school nights with moms, with alternating long weekends or extra time in the summer for dad. There's fewer handoffs, less car time, and therapy stays consistent. The schedule fits the child instead of forcing the child to fit the schedule. Both situations would be fair in the eyes of the court. They are just fair in different ways because their facts are different. That's what looking at the best interest of the child is all about. So now let's dive into the child support. Florida uses very strict guidelines to calculate child support. That means the number is built from math, not from feelings. The big inputs are simple. Both parents' monthly net income, number of kids, and the child's portion of the health insurance. Work-related childcare, like daycare and aftercare. And finally, the number of overnights from your time-sharing schedule. Judges can make small adjustments to the guideline number, like 5%. But to deviate any more than that, the judge has to document why they're doing that and what's the reason. And if you've heard of those cases where someone tries to stop working or take a lower-paying McDonald's job just to avoid child support, that doesn't fly in Florida. If someone can work but chooses not to, the court can calculate their income based on their work history and what they could be making. Or worst-case scenario, just minimum wage. So let's take a look at some simplified child support scenarios I made up just to show you how this works. In family A, mom and dad have nearly equal time sharing and very similar incomes. Parental responsibility is shared. Overnights are close to 50-50. Both parents work with a very similar take-home pay. In this case, there's not going to be a big child support number, if there's any at all, because the incomes are close and both homes carry a lot of day-to-day costs. But family B, it's very different. Both parents have similar incomes, but school nights are with dad, and mom gets every other weekend. Overnights are not close to 50-50. That means mom is going to have to pay dad child support because that home covers more overnights and days. And in family C, both parents have equal time, but unequal incomes. Let's say dad makes $150,000 a year, while mom only makes $60,000. Just because dad has equal time does not change the math when it comes to income. The court is going to expect dad to pay mom child support to keep the kids' standard of living at what they had when they were all together. Now, there's a ton of other scenarios I could run through, but remember, the guidelines and formulas that the court uses aren't just made up. They're actually the law spelled out in the Florida statutes. And when you work with our firm, they're the same ones we will walk you through to give you a solid estimate of what that child support is going to look like. Now, before we wrap up, there's a few very common misconceptions about time sharing that I want to make sure and dispel. First, the judge can just pick mom over dad. Nope. In Florida, they have to look at the best interest of the child, not traditions, not labels. The court starts at equal time sharing and changes it only if the facts show a different plan is better for your child, or if the parents don't actually want equal time sharing. Next, day hours count just like nights. Nope. Overnights are the anchor because they're easy to count and tie to real costs like food and routines. Sometimes I'll hear parents say that weekends should count for more because the kids aren't in school and are spending all day with the parent, but that's not the way it works. The formula uses nights, so everyone is counting the same thing. And last, parents can agree to ignore insurance or childcare to make the support lower. Those are add-ons that have to be calculated into the math. Although you can pull out the numbers, they still need to be calculated together with the child support. Custody and child support are huge issues when it comes to deciding if you are ready for divorce. But they're not the only ones. If you're in Florida and you want to know if you've thought through all the big decisions you'll need to make, take our divorce readiness quiz. It's free, confidential, and takes about less than 5 minutes. You'll get a good overview of the things you may still need to think about and get in order. Then you can decide if it's the right time to speak with our team. All you have to do is click the link in the description. But I do have to sound like a lawyer for just a minute. This is just a quiz. Your results are informational only. This is not legal advice, and taking the quiz does not create an attorney-client relationship. They just help you to see some of the things you need to be thinking about. And if you're already sure you're ready to move forward with your divorce, you can contact my Miami office for a free case evaluation and a strategy session. So now you have a solid understanding of the big things that factor into time sharing and child support in Florida. Next up, we will tackle how alimony is decided. It is not as cut and dry, and the alimony in Florida changed a lot not too long ago. Until then, I'm Vanessa Vasquez de Lara, the founder of the Vasquez de Lara Law Group, the firm that makes lives better in and out of family court. See you soon.